Moving on to the ethics portion of our program, and our first speaker, Nikki Nesbitt of the Baltimore firm of Goodell DeVries Leech Dann. Nikki clerked for U.S. District Judge Schultz in the District of Maryland. Her cases are primarily in federal court and the circuit courts throughout Maryland. She's on the executive board of the Maryland Defense Council, is co-chair of its Young Lawyers Committee, and is also very active in DRI as a member of its Ethics Committee. Nikki handles commercial litigation, civil rights defense, professional liability defense, products liability defense, and employment law. Nikki's going to discuss ethical considerations of e-discovery. Please welcome Nikki with me.
Thank you. Thank you for coming back and sticking with us this afternoon. Well, you can't get very far in your day without having some reference or another to social media, and maybe some of you have been tweeting throughout the day about how fabulous this program has been. I'm here to talk to you today about discovery of social media and surveillance of your adversaries and witnesses through use of social media and the ethical considerations involved in those things. So here's an example of what we're talking about. Here we have an employee who had a bad day at work and, like many people, goes to her Facebook page and decides to tell all of her friends on Facebook how much she hates her job and her boss, inadvertently forgetting that one friend is said boss, and the boss takes that delightful opportunity to comment on her post and let her know that her services are no longer needed at the job she hates. There are a lot of uses for social media, that being one example. For you in-house lawyers and employers, using social media to check up on what your employees are doing can be very useful, and we'll get into some examples of that as the presentation goes. But in a litigation context, social media postings can be very useful for checking up on your plaintiff or your adversary, looking up some witnesses that you might be deposing, perhaps even finding new witnesses through posts of your plaintiff, learning about jurors and judges as well. And there are a lot of sources for this information. So when we talk about social networking sites, we're talking about those sites where individuals have accounts where they set up profiles that describe things that they're interested in, and they can create postings about things that are of interest to them, things that they're doing with their day, things that are on their mind, and so forth. Facebook and Google Plus are probably the two most popular and most informational sites for that, but there's also Twitter, which is very interesting if you can follow someone on Twitter, because you get kind of a stream of consciousness thought process, which can really be useful when you're trying to find out more about a person. In addition to those social networking sites, you've got information sharing blogs that individuals often create for themselves. And what I found to be very interesting in a personal injury context is that individuals who have undergone some sort of traumatic event, a big injury, a big illness or something, and they have family members who are constantly asking them how they're doing, have taken to sites like caringbridge.org and other blog sites where they can have a running journal of kind of how their recovery is going. It's a great source of information about how their recovery is going, and you might actually be able to use that in your trial. So these are really good sources for information about your plaintiff. There's also image sharing and video sharing sources of information. These are sites where people post their own photographs or sometimes tag things of interest to them. And the usefulness in that is, well, if they're posting photographs of themselves, you can see kind of in photos what's going on in their lives. That can be very interesting. But I've been able to use this too in, for instance, a case in which a plaintiff is claiming that she has post-traumatic stress disorder because of my client's conduct. She's not able to do anything anymore. She sits in her house all day. She has no interest. She has no friends. You know, she doesn't do anything. But she is active on her social media, and she is posting interesting pictures of things that she's doing, or at least showing an interest in other things, and so it kind of belies her claims of PTSD. So there are a lot of sources for getting this useful information. There are a lot of examples in litigation and outside of litigation for how this is being used in the real world. In the employment context, there are a lot of examples of employees being kind of caught doing something that their employers don't appreciate and then having adverse employment action taken against them as a result of that. These two examples are from North Carolina. Recently, a waitress was fired after she posted that there were cheap tippers at her restaurant, and her restaurant didn't appreciate that. An elementary school teacher posted as part of her profile on Facebook that she teaches chitlins in the ghetto, which her school didn't really appreciate too much either, and she got demoted for doing that. This is an example that kind of went around the circuit a little. This is a bank intern who claimed to have needed Halloween off, and he kind of implied that there was this family emergency. And later the same day, he's posting pictures of himself in a Halloween costume, and he didn't come back the next day. And in the personal injury context, as I alluded to before, imagine if you have a case where your client is being accused of causing injury to a plaintiff who claims that they have a permanent injury now to their foot, and you come across this post on their Facebook page saying, "My foot is healed." Great information for cross-examination at trial. This can get people into trouble from a legal standpoint as well, from a criminal standpoint. This is an example of a woman who was collecting workers' compensation benefits because she could not work, allegedly, but she was caught on Facebook boasting about her new salary. She was actually criminally prosecuted and fined and given probation. So there's a lot of examples of this kind of thing being used to the benefit of defendants in litigation. But there are limits to both what you can access and how you can access it. And that's where the ethical rules come into play. We actually have two kind of issues here for you to be aware of. One is the privacy considerations that are attendant to people's use of social media. And then the other are the ethical limitations attendant to your capturing of those postings. You would think that in the context of social media, it being such a public thing to do, that there wouldn't be privacy interests at stake, but there really are. There have been many cases that have assessed this situation to determine whether there is a reasonable expectation of privacy in posting on social media, and there is. And what you need to understand is how these social media sites work. They are not public communications. They are communications to a very large audience, but users of social media can put privacy protections on their sites so that only certain people can view the content. And although their audiences tend to be broad and they tend to be maybe not all that smart about who they invite to see all this stuff, they don't necessarily invite the entire public to view their postings. And the reason that that's relevant to all of us is that while we can, as just a normal person in the universe, go online and Google a person and find out if they have a Facebook page, we can't necessarily get at the content of that Facebook page unless we are authorized to by becoming this person's Facebook friend or this person's follower on Twitter. So we don't automatically get at this information, and what that means is that people who have had their content viewed by people if they didn't intend to view it have raised privacy complaints, and the courts are sort of mixed in their views on that. But we are seeing that privacy protections are being upheld for social media, even though social media is sort of designed to be kind of a public form of communication. In the employment context, there is a lot of attention being paid to what employers can do about applicants and employees in terms of monitoring their social media. Generally speaking, in the employment context, when someone applies for a job, an employer can't ask them for certain information about protected statuses, like they can't ask for applicants to disclose religious beliefs or political beliefs or even race and ethnicity at the outset of an application. But if an employer receives an application and then goes and does a social media search for this person, they can get access to a lot of information they otherwise wouldn't be able to ask about. And the reason that you want to be aware of that interesting divide there is because if you gain access to information about somebody's protected status in some way, and you decide not to hire the person, and they find out that you have gained this information and then decided not to hire them, you've kind of opened the door to a discrimination claim there, even if that wasn't the basis of your decision not to hire. So this is gaining a lot of attention now, even in the legislative context. And it applies as well to existing employees. Imagine a scenario where an employer is simply monitoring employees' social media just to make sure that they're acting professionally and not misrepresenting anything about the company. I mean, it seems like a very fair thing to do, but they're also gaining access to personal information about the employee that they otherwise wouldn't know in the normal course of the professional relationship. So there are situations where an employer might decide to take adverse employment action against someone after viewing social media postings that this person has made, and they kind of open themselves up to a discrimination action if the plaintiff wants to say, hey, listen, you wouldn't have known about my religious beliefs or my political beliefs if you hadn't been doing this. I think that was the basis of this decision, and now that issue is out there. Interestingly, several states are now enacting bills or putting bills out there concerning employees' rights not to have their employers require that they give over their passwords to Facebook and give them access to their social media. So a lot of employers have a policy of saying, you need to permit me to monitor your social media. Employees have really cried foul on that, and we've got states, at least 6 states in the last 2 months have enacted or put into circulation bills that would limit employers' abilities to monitor the social media because of this privacy issue. If the employee doesn't want them to be the Facebook friend, then they can't compel that to happen. And just on August 1st, I think Illinois signed one into law. So something to be aware of. But these privacy protections do have their limits, and this is an important distinction. While the courts have said that people have a privacy interest in what they're posting, that doesn't mean that it can't be disclosed in the course of discovery. It means that maybe surveillance is not appropriate, but asking for something in discovery could be. So in these 2 cases, we have sort of variations of that theme. In the Kwan case, which is a Supreme Court case, the Supreme Court decided that a text message sent by a police officer over a department-issued pager was not subject to a privacy protection. It was still subject to a search and seizure that had probable cause. And then in the EEOC case from Indiana, the court decided that an employer could request in discovery and compel an employee to produce a Facebook page, even though it was a private Facebook page, because it was relevant to discovery. So the courts have said in the context of formal discovery, whether it's in the criminal context through search and seizure, or it's in the civil context through regular requests for documents, it's appropriate to ask for this information and to get it. There's not a privacy protection that would make it not discoverable. But here come the ethical pitfalls for how you obtain this information. There are a lot of rules that come into play that sort of govern the area, everything from competence to confidentiality and communications with represented parties. On the competence side, this is sort of on the one hand, you need to be aware of what's out there so that you can competently represent your client. I think not enough people are really trying to go after the social media, notwithstanding how rich in information it is. So be aware of what's out there and ask for it in discovery and follow up on it. You want to make sure that you're complying with that sort of basic competence provision in the ethics rules. But on the other hand, there is this issue of communicating with a represented party, communicating with an adversary, and communicating down the road with jurors and judges. This San Diego ethics opinion that's listed here has a really nice comprehensive analysis of this communication issue. And what it says is, It's unethical for a lawyer to friend a person in order to gain access to the content of that person's Facebook page. And the same would apply to other forms of social media, Twitter and Google+. It is unethical for you to try to get access to someone's Facebook page by friending them, because the act of submitting a friend request is an ex parte communication with a represented party. That's basically what it comes down to. And if you know Facebook, you know that when you issue a friend request, you basically hit a button, and what that person receives is something from Facebook that says, so-and-so would like to be your friend. And they then accept it or reject it or ignore it. Even though the ethical rules say you can't have a communication ex parte with someone about a matter, the ethics opinion, this ethics opinion and other ethics opinions have followed suit, has said a friend request is about a matter, because what it's essentially saying is, I want to be your friend so that I can see all of the content on your Facebook page about that might be relevant to this case, and then I will use it against you. And that's basically what the ethics committee said. They said that that's what a friend request is really saying. And if that's what it's saying, that's an ex parte communication under the ethics rules, and it's not permissible. So you cannot send friend requests to witnesses and represented parties in order to gain access to their Facebook page. This is another example of that, but in this case, the lawyer knew that if he tried to friend the witness, they would just reject it, so he asked his assistant to do it. You can't do that either. So the rules that come into play are these basic rules. If you can't friend your opponent, then neither can your staff. You have the responsibility to make sure that your staff are not doing something deceptive, and that is something that is considered to be a deceptive practice. What about dealings with your own client? This is another interesting kind of variation of the theme. You are all representing individuals. Even if you're representing companies, you have individuals who may have social media of their own. What happens if you get a request for that person's social media? What can you do to protect your client from what might be discovered on the other side? There are restrictions, just like in any other context, about instructing clients to destroy their social media. It's the same rules that apply to spoliation generally. You cannot tell your client to go and destroy their Facebook page if there's been a request for it. The most comprehensive case that I'm aware of on this is this one out of Virginia. It involved a 25-year-old woman who was killed in an accident. It went to trial. There was a substantial verdict for the plaintiff. In post-trial motions, it was revealed that there had been a discovery request to the husband of this decedent for his Facebook postings, and his lawyer told him to get rid of it, which he did. And then in answering discovery said, I don't have a Facebook page as of this date, which was true because he just deleted it. The result of that was a remediator of half of the husband's award. The counsel was referred to the Virginia State Bar. The husband was prosecuted for perjury. There were sanctions, $542,000 in sanctions issued against the lawyer, and $100,000 against the husband himself. So, moral of the story is don't do that. You can, however, instruct your client not to continue to post things. There's nothing wrong with doing that. You want to make sure that your clients are aware that they are under scrutiny and that they shouldn't be posting things that are imprudent for the case. You can also instruct your client to make things private so that they can't be viewed by everyone under the sun. So you want to make sure that your client has privacy settings like most smart people do nowadays so that things are not publicly available about them. In terms of jurors, it's interesting that the ethics commissions are generally saying that it's appropriate for lawyers to investigate jurors through use of social media or otherwise. That's okay. However, you, just like with witnesses, you can't friend them in order to gain access. And the way that it's been put by the New York Ethics Commission is You can look for stuff about your jurors, but they can't know about it. Because if they know about it, then that means you're communicating with them, and you can't communicate with jurors. So you have to do it surreptitiously. But you can do that. That's okay. And on the judge side, I think I just thought this was interesting. Judges are, for the most part, permitted to be friends with lawyers who appear before them. It's okay for judges and lawyers to be Facebook friends, even though they have cases together. It's not appropriate for them to communicate about the cases, obviously. Florida is the outlier on this. In Florida, you can't be friends with judges, and judges can't be friends with you on Facebook. It's just something for you to be aware of. So in conclusion, what I would want you to take away from this is you cannot have ex parte communications with your plaintiffs in trying to find social media out there on them, but there are ways to get that information through formal discovery and through whatever is publicly available, and I encourage you to do that. It's a great resource. Thanks very much.